Welcome to this explainer. Today, we're taking all that intimidating, dense legal jargon and translating it into a clear, actionable playbook to protect your rights during a Georgia DFCS investigation. If you're a parent in the state of Georgia, this is absolutely crucial, need-to-know information.
Let's dive right in. We are focusing specifically on the laws, the case law, and the procedures right here in Georgia. Because when the Division of Family and Children's Services gets involved, knowing the exact limits placed on their investigators isn't just helpful, it is essential for protecting your family. Because a DFCS investigation can feel pretty chaotic, we've broken this down into 5 manageable phases: the setup, the encounter, the paperwork, navigating court, and finally, fighting back. Phase 1. The setup. Understanding what DFCS is actually investigating. So when investigators open a case, they're actually asking 2 totally separate questions. Did maltreatment likely occur? And is the child currently safe? Now, why does this distinction matter to you? Well, because a case can find absolutely zero evidence of abuse, but the agency can still keep it open and highly restrictive if they claim the child is unsafe for some other reason. It's a critical nuance. You also need to keep in mind that DFCS investigations are expected to conclude within 45 calendar days of intake. That means you are working on a very fast, very short clock. Never assume this process will be a slow burn. The agency is moving at lightning speed, and you literally need to do the same. Moving on to Phase 2, the encounter, or as we like to call it, the knock on the door. When that highest point of anxiety hits, your best defense is definitely not arguing. In fact, arguing is incredibly counterproductive because hostility is literally written down as a risk factor in their files. Instead, you want to control the scoop of the encounter by following these exact calm steps. Stay calm, ask for ID, ask for specific allegations, decide if you'll allow entry, which remember you do not have to do, and document absolutely everything. Just look at the difference in approach here. Asking simply, "What are the specific allegations?" is vastly better than offering defensive statements. Don't try guessing what the visit is about, don't volunteer unrelated family history, and definitely don't argue about the investigator's motives. Giving minimal, factual statements and asking for their requests in writing is going to be your absolute safest posture. Always remember your constitutional shields. DFCS investigators cannot force entry into your home without a court order or a true life-or-death emergency. There is no social worker exception to the Fourth Amendment. Entry requires your active consent, a warrant, or exigent circumstances. And equally important, you have an absolute Fifth Amendment right not to incriminate yourself. You can, and really should, decline detailed questioning until you've obtained legal advice. Now, under Georgia law, there is an incredibly strict legal threshold investigators must meet to remove a child without a prior court order. It's called imminent danger. By definition, this must be an immediate, significant, clearly observable threat of serious harm if action is delayed. It absolutely cannot just be a vague suspicion or a hunch. Phase 3, the paperwork, navigating the safety plan trap. DFCS often proposes what they call voluntary safety plans, but voluntarily signing these plans can actually be weaponized against you later in family court, essentially treating your signature as an admission of guilt. So you must demand clear written answers to these 5 questions first. Ask them, what specific safety threat exists right now? What exact restrictions are you imposing? What is the end date and measurable path to ending this plan? Are you filing in court if I refuse? And will this be used in custody litigation? Never, ever sign blindly. Phase 4, navigating court, a plain English breakdown of dependency court. If DFCS does file in juvenile court, notice how incredibly fast this moves. You go from a 72-hour probable cause hearing straight to an adjudication hearing within 10 to 60 days. At adjudication, DFCS must legally prove dependency by clear and convincing evidence. After that, within 30 days, comes the disposition and the case plan. It's a whirlwind, which is why preparation is everything. And finally, Phase 5, fighting back, legal shields and motions. First things first, remember your standing. Your rights as a parent are backed by the United States Supreme Court. Just look at the precedent set in Troxel v. Granville, which established that your interest in the care, custody, and control of your children is one of the oldest fundamental liberty interests recognized. You have immense, powerful legal standing to fight for your family. Don't forget that. Because you have these rights, you must file a motion to compel DFCS records. Relying on the landmark precedent of Brady v. Maryland, the state is required to disclose all exculpatory and material information. Basically, they cannot legally withhold evidence that is favorable to you, and you have an absolute right to the complete case file so you can properly prepare your defense.
Furthermore, you can fight back against unverified rumors. By filing a motion challenging admissibility, you force DFCS to meet Georgia's extremely strict business record exceptions. And here's the kicker. Records specifically prepared just for litigation do not qualify. This is a massive tool because it effectively blocks unverified secondhand hearsay from ever entering the courtroom.
And lastly, if it comes down to a case plan, never accept a one-sided agreement where you do all the work and they do nothing. Legally demand that DFCS put their own service obligations in writing. You should also request an objective, independent expert to evaluate your family fairly, rather than relying solely on the agency's own evaluators.
You need to start organizing your proof today. The fastest way to lose ground in these situations is delay, and the fastest way to gain it is through calm, structured preparation. Knowing the immense power of your constitutional rights, are you prepared to build a paper trail of safety and control the narrative today?